All right, I started the recording and it's about 2 p.m. Eastern time. Thank you for those that have joined us. As you know, I'm Gordon Berger, and I have a special guest today, my partner, David Renner, who is a employment lawyer like myself. And he and I will go through this agenda today. A couple of housekeeping items to start with. First is that obviously, if most of you have done business with me or with David, you know that FisherBroyles is our firm, and we are Law 2.0 because we do things differently than a lot of firms. Nevertheless, for our purposes today, we are not sitting with a hat on as your lawyer, but as a presenter of information. And so don't take this back with you as definitive legal advice and don't rely on it. Just informational purposes only. If you have specific issues and questions that pertain to your company, I suggest that you offline contact David or myself, and we'd be more than happy to work with you on your issue. Most of you also know that this is a full service law firm, although David and I do wear employment law hats most of the time. The firm has a lot more hats to wear, and you can see them here, which is an abundance of different areas of law that we handle, which, as most of you know, means we do everything and anything. So that being said, here's our agenda for today. And we're going to go over these items. In order for us to give you a legal update on everything happening in 2022, we would have to do a multi-day webinar, which most of you would fall asleep before we ever got to that point. So we're going to talk about where we are with the vaccination mandate. We're going to talk about some wage and hour issues. And then we're going to talk to you about restrictive covenants updates, which some of you may have attended my webinar in September. It's an update on kind of where we are there. So having said all that, I'm going to turn this over to Dave, and we're going to talk about where we are with the mandates.
Thanks, Gordon. And thanks everybody for joining us. So I think between Gordon, myself, and two of our other partners here at the firm, we've beaten the vaccine mandate train, or that horse, to complete and total death over the past couple of weeks. And many of you, I'm assuming, have probably tuned into those Zoom meetings that we've had. So we're going to be kind of brief with these mandates. And the first one, and actually this is hot off the presses as of yesterday, but we know that there was 3 separate vaccine mandates that were issued. There was the OSHA ETS, there was the federal contractor mandate, and then there's the CMS mandate applying to healthcare entities. So as you can see here on the slide, so back in November, there was a district court in Louisiana. They issued a nationwide injunction enjoining the implementation of the CMS mandate nationwide. So as of that date, there was no vaccine mandate for healthcare providers. And there was also a case issued out of the District of Missouri that issued a similar injunction, but that only applied to the states that filed suits. And those states you can see are listed at the bottom of the slide here. But yesterday, December 15th, the Fifth Circuit removed the nationwide injunction issued by the district court in Louisiana, and said that they exceeded their authority to issue a nationwide injunction, but they did limit it to the 14 states that had, I guess Louisiana and the 13 states that joined the suit. So if you are in one of the 26 states that is not listed here on this slide, and I won't go through each one of them, you are now subject to the CMS vaccine mandate once again. Little wrinkle, I don't know what that exactly means. Because while there was an effective date in December that then got pushed back to January, CMS came out and said that they were going to halt all their enforcement efforts while the injunctions were pending. So I am going to assume that we're probably going to see 2 things. One, we're going to see more lawsuits being filed in more states to get this thing potentially blocked nationwide, or those lawsuits that have already been filed are going to start moving forward a little further. Or in the meantime, CMS is going to revise or reverse that memo and say that they're only going to enforce it in the 26 states not subject to an injunction. And I'm going to assume that that is going to include a new effective date or a new enforcement date, but we'll have to wait and see.
And David, and you probably remember, and I'm just going to mention this to folks. So about a week or two ago, there was an extension of the comment period for this mandate. So if it restarts, at least there's a period by which there's some comments that the public can submit. So it won't be implemented immediately. That we know for sure. So I just wanted to clarify that.
Yeah. Gordon, can you move over to the next one? So the next, we've also got the OSHA ETS. This was the vaccine or test mandate that applied to all employers with 100 or more employees. But as we all have heard, the Fifth Circuit initially stayed that order or this ETS, and the case then got transferred to the Sixth Circuit. And a number of unions have petitioned to move that case from the Sixth Circuit to the DC Circuit because they claim that the DC Circuit is better equipped to handle it because they heard those unions brought a suit previously in the DC Circuit to force OSHA to issue some health and safety regulations earlier on in the pandemic. There was a petition filed by the folks that brought the lawsuit, all the various industry groups and companies that brought the suits in the states, to have the decision reviewed en banc by all 16 judges in the Sixth Circuit. But that motion yesterday was denied. And so it's going to go forward on a 3-judge panel, like most appeals do. And it seems that the Sixth Circuit does not appear to be particularly motivated to move this thing along quickly. So this thing could be sitting out there for some time. The other vaccine mandate we know is the federal contractor mandate, and that was last week. So this applied to all federal contractors that met various or certain specific criteria for a federal contract, and that was a vaccine mandate only. And last Tuesday, the 7th, a Georgia federal judge issued a nationwide injunction blocking that mandate, and so that one is also on ice. So right now there are no currently effective vaccine mandates issued by the federal government, and as we roll in here into 2022, but things that could change depending upon what happens in the courts and with the new any new actions taken by OSHA, CMS, or the executive branch on the federal contractor mandates.
So before I get into federal wage and hour, David, there was also a case that was declined to be heard by the Supreme Court out of the state of New York, where there was a mandate, but it did not have an exemption for religious purposes. So I found that interesting. The court let that stand, given what the standard was going to be at the federal level. So that could be another outlier that we have to look at as we head to 2020.
Yeah, absolutely.
All right. So I'm going to talk a little about federal wage and hour. This one is related in the next slide to tipped employee rules. So there's been a lot of back and forth at the federal level on when you have to pay minimum wage for workers that are under a tip credit. And so, the tip credit is, so like a waiter or waitress gets $2.13 an hour and plus tips, and any under minimum wage, the employer subsidizes thereafter. And in most cases, they make more than that because the tips are supposed to offset beyond the $2.13 an hour. Well, the rule got kicked around, and there was an 80-20 rule that was in effect that, that tip rule I just described would apply as long as for the majority of the duties that the employee was providing were at the tipped job. So 80% of that and 20% was non-tip rule work would not throw that tip credit out of out of play. So the rule is now changed that you're paid the tip credit for the time you're working and in that occupation, and if doing something else, the employee would have to get at least minimum wage. So that's a modification to the 80/20 rule. The other component is on tip pooling. So there's been a lot of controversy over, for instance, waiters and bartenders sharing tips in a pool and dividing them up amongst the various employees, where in some cases either management or they were including in the pool, say, a busboy or a cook or somebody in the kitchen, and that had raised some issues because those aren't tip occupations. And so we've got a clarification now that first of all, there's now a right of action if the full tips are not given to the employers. It's employees. It's clear employers cannot keep any of the tips that come in from customers. Also, if the employer does not employ the tipped credit, the tip pool can be shared with non-tipped occupation, like the busboy or the cook I mentioned. But at no time can a manager or other supervisory folks share in those tips. So, Dave, tell us about what's going on at the state level in 2022 with wage and hour.
Yeah, so there's a number of fun developments that we'll get into, some specific developments at certain states in a few moments here. But as you can see here on the screen, it's a new year in 15 days, or I guess technically 16 days. And typically with the new year comes potential increases to the minimum wage effective in each state. So there's no the federal government hasn't changed anything in terms of the minimum wage. There's talks about maybe doing that, but right now we don't have any increases to the federal minimum wage. But as you can see here on the map, and I think it would take the entirety of our time together to go over each specific state. But as you can see on the map, anything in yellow has minimum wage increases that are taking effect on January 1. And blue, the light blue, there's no changes. So if you're in one of those states, you don't have to worry about anything. The dark blue, there is no minimum wage, so you don't have to worry about that. And in green, you could see down below that there are some more specific other increases, more specific increases in those states. And in addition to just the minimum wage, something to note, some states, and kind of went in conjunction when the federal government was talking about it for the exemption, the salary basis test for the exemption requirements for minimum wage. Some states, I know, Pennsylvania passed a law that was going to start stepping up those amounts, periodically year over year. They just hit a landmark in October of this past year. So, you want to keep an eye out, not just for whether the minimum wage has increased, but whether or not the minimum salary you have to pay exempt employees is going up for 2022. So something to keep an eye on.
All good points. And by my math, about half of the U.S. states have changed the wage and hour laws coming 2022. So it's significant that it's going to touch probably most of the people on this call.
Yep. So California, our favorite employment law state. So there's a couple of changes that happen in California here that are effective on the first of the year. So the first is California SB 572. So this is, there's an existing law that allows the labor commissioner to hear employee complaints regarding, wage payments and other employment related issues. There, it imposes civil penalties for violations of the state law for, if you fail to pay the minimum wage, fail to pay, successor liability, fail to pay, don't have various licensure requirements, so on and so forth. And in addition to imposing civil penalties, to issue a judgment lien. So if they obtain a fine or they issue a fine, they can go into court and issue a judgment lien, and then it goes to it's handled in that regard, how to collect it under the laws of California. But they've also just amended the laws effective January 1. If you violate these laws, the commissioner can now place a lien on real property to recover penalties owed for violations of the labor code. So in addition to just having a judgment lien issued, they can go actually out and place a lien on a business's warehouse or headquarters if they own the building, or any type of real property that the company might own as an attempt to collect it. So if the company tries to go off and sell that property, they're going to have to clear that lien before and satisfy essentially the judgment before they can sell the property. Another major change is California AB 1033. So this is specifically dealing with the California Family Rights Act. This law has quite a few changes to it. The most significant change is the California Family Rights Act provides, it's the state law equivalent of the FMLA. So they have to provide 12 weeks of unpaid leave during any 12-month period. And one of the categories under the CFRA is an employee can take leave to take care of their parents. This law amends it to now cover parent in-laws as well. Previously, it was not covered, and effective January 1, it will cover your in-laws. So if your in-laws get sick, you can take CFRA leave to care for them. Note, this is different than under the FMLA, which does not cover in-laws. So this is, something that benefits employees more in California. So California employers are going to have to make sure they're providing their employees with leave to take care of their in-laws. There's also under existing law essentially a mediation program if there is an alleged violation of the CFRA. And the amendment taking effect on January 1 is if an employee requests the right to sue through the state agency has to issue them a notice that you should go to mediation first and try to resolve it before bringing your claim into court. And it also allows employers to request mediation when those claims are filed, and the parties then have to go through the mediation process. But if the most significant change here is if there is a lawsuit that was filed and against an employer that has between 5 and 19 employees, and the civil actions brought, the employer can move to stay that civil action or an arbitration if it's an arbitration, if the employee failed to initiate that mediation process prior to filing the civil action, and then that case is going to be stayed until the mediation is either complete or some type of impasse is reached during mediation and the parties just can't resolve it. So it's essentially creating a mandatory mediation program when it comes to the CFRA type claims. And so that's it for California. Moving on to Illinois, another more employee-friendly state. They essentially rewrote their Equal Pay Act. They have a state Equal Pay Act, which is what Illinois House Bill 1207 it has replaced. They essentially repealed everything and then rewrote it. Most of everything is staying the same. It still prohibits pay discrimination based upon sex, and you also cannot pay African-American employees differently. Interestingly enough, it's not a blanket race issue or designation in the law. It just says sex and African-American. But the other big thing, and this existed before, employers were prohibited from asking an applicant's salary history during the application and hiring process. That still remains, but now there's a specific provision in the bill that allows employers to provide the information about the compensation for the position that the employee is applying for. curious why that needed, or why they felt that needed to be added in. I would think that any employer would want to tell the employee how much they're going to be making in the job that they're applying for, but they felt the need to include that. And it's also written into the bill that you can discuss the employee's expectations regarding their salary for the position that they're applying for. That can happen during the application process. You can ask employees, hey, what do you're applying for this job, this is what it pays, or, what do you expect to be paid coming into this position? Note, it's not a violation if the employee volunteers their salary information. So you're allowed to know about it if the employee on their own tells you about their prior salary history. But importantly, in the law, you can't use that in either making a hiring decision or in setting that employee's pay rate when, if you do ultimately end up hiring that employee. I think that's all I have on Illinois' wage and hour law.
All right, we'll pivot to me and we'll talk about Minnesota. So Minnesota is coming in line as of the first of the year with a lot of states that are mirroring the federal law. And how they're mirroring it, they are requiring lactation breaks, but also in this case, full pay for the time involved with lactation, as well as accommodation for pregnancy or childbirth related health conditions. Again, this kind of mirrors the federal law, but some states have gone a little further on terms of paid or unpaid leave for time off, or in this case, Minnesota has also stipulated that employers can't mandate that the individual take the leave or accept an accommodation. So that's a bit different. And again, it's kind of part of a trend, however. Likewise, with Washington. So David talked a minute about California. Well, California, the state can impose a lien upon the employer's property if there's a wage claim. In this instance, other than highly compensated employees, your average employee has the private right to file a lien. Of course, I wonder if a company, in this case, it says real or personal. In California, it's just real property. Kind of wonder if they don't own any property, how you enforce that. But in this case, it could be, I suppose, on a bank account or anything tangible. But it's an interesting trend that's developing, because historically, in order to put a lien on an adversary or someone you believe owes you money, you would have to first get a judgment and then do a levy, which a form of levy is a lien. So this is interesting. It kind of lets you jump right to it. And I don't know how that will play out, but I don't even know if there are going to be ways to bond or otherwise remove liens. It clouds the title to property, and it could lead to other issues. Is it something you'd have to disclose, such as for a license renewal, or from a regulatory perspective, if you're trying to identify what your company has or hasn't done as far as whether you're in violation of anything. So it's going to be interesting, at least for me, to see how that all is going to play out. So that's another trend. Now, before I talk about the Great Resignation and people moving from job to job, I did want to mention, so time isn't permitting us to talk about a number of other areas that are trending in the employment arena. Certainly, we thought it was more important to talk about wage issues and restrictive covenant issues, but there are other trends that you should be aware of. One, of course, is a ban the box related to not being able to ask certain questions about criminal history. And another, of course, is salary history. Another is lactation breaks, which I did allude to. And there's other areas that are becoming more of a trend as well. But again, time doesn't permit. But at the end, if you're not already subscribed to my newsletter, you can send me an email. I do a legal alert every Friday. I try to cover topics around the country as well as any federal of significance. And of course, we do periodic webinars. So we try to help you out as best as we can, at least stay on top of the more important developments. So that being said,
and Gordon, real quick,
yeah.
another area that's trending, I think that's important to mention or highlight is drug testing. There are other states and localities that are starting to prohibit drug testing for applicants. Maybe not blanket prohibition of drug testing, but not being able to drug test for marijuana specifically has become one of the big ones that they're
Right. New York,
governments are stopping employees to do, or
yeah, I
employers from
think
doing.
New York and Massachusetts come to mind. Am I right, David?
Yeah, and I believe in New Jersey is another one that happened earlier on in the year, and Philadelphia just passed an ordinance, I believe, as well, prohibiting that. So,
well, and I'll throw one more in there. How's that? We'll give you a bonus. Artificial intelligence for recruiting and hiring is becoming an issue, as well as bioscans and use of such bioscans in employment, meaning like a retinal scan to use for security purposes. So you would open a computer or a secured door or file that way. These are emerging because of technology trends. It's the bio started in Illinois, but it's expanding into other states. So more to come on that at some point. That may be a full-blown webinar, but right now it's just kind of be aware of it. So if you haven't heard, and if you are not a frequent communicator with me in some way, then you would be oblivious to the fact that the world has changed. Employees have become quite empowered. As I told my daughter, they're punching their own ticket. Folks are able to dictate what they want. They're able to leave for significant increases in salaries. Even though unemployment is down like 188,000 claims this week. It's the lowest since like 51 or 52 years of tracking. Yet we still see shortages, and yet we still see issues with labor. Why? Because people are tired of doing certain kind of jobs. The pandemic has pivoted people into different areas, and there's a lot of more movement. Well, what runs directly into the way of that movement? Restrictive covenants. Why? Because they don't allow you to compete with your employer, for instance. Don't allow you to take confidential proprietary information. It may ban an employee from recruiting customers and or former coworkers to a new company. And so a lot of questions will come up. David's going to go over some of the moving parts of this, but can you hire people that have these covenants? And if so, could you be sued? If you have employees sign these, and sometimes they're a longstanding employee and the agreement might be quite old and maybe a little archaic even. And so, as a side note, you should have these reviewed and updated periodically. But do you try to enforce it against somebody that leaves? If you sit on your hands and decide to let it play out, does that have an impact if you don't enforce it right away? Can I down the road decide to do it? These are all questions and considerations that are case by case, fact specific. State law is dictating. But as many of you know, we also have had some push from our president to more legislate these type of laws. But first, I'm going to let David get into the weeds on non-competes and the general proposition of what they are, how you do them, are they enforceable, so forth.
Yeah, thanks, Gordon. So, the law for non-competes or any restrictive covenant, it's up until and we'll talk about it in a minute, whether or not the federal government's going to get involved. It's an issue of state law. So while there are similarities, there are generally 50 different versions of the restrictive covenant law out there right now. But they all generally fall under the categories that we have here to be enforceable on the slide here. So you have to have some type of valid business justification, such as protecting your confidential or proprietary information or your trade secrets. You can't just stop somebody from competing against you because you don't like them or you don't want them to compete. You have to have some type of valid business justification, such as the employee knows all of your customers, knows all your trade secrets, knows all your confidential information, and it would be harmful to you or unfair if they were allowed to go work for a competitor. The restrictive covenants also generally have to be no greater than necessary to protect the employer's what's called a legitimate business interests. And that, as you can see, we got that in quotes, and that's a defined legal term of art that has various meanings across various different states. And I'll get into some states that have specifically defined that in statute, or it's been developed in case law. But that generally goes into, the legitimate business interest generally ties back into those valid business justifications. So protecting that confidential information, protecting your proprietary or trade secrets, protecting your customers or your customer lists. Interesting note, you can't have a legitimate business interest in protecting your, for instance, your customers or your pricing information or something like that, if you make that information available to the public. There has been cases, I know in Pennsylvania, where employers have gone to enforce a non-compete and saying, well, they know our pricing and they know all of our customers. And if you Google the company's name, it pops up and it says, here's a list of all of our customers and here's what it costs to do business with us. So that can't be a legitimate business interest because there's nothing, secret or, needing to be protected if you're advertising it to the public and to your competitors.
David, question for you. So this is a classic for marketing. What if I put on my website a quote from a customer and I say, Bob with Widget Co. is touting how great we are as a company. We've identified him as a customer. Have we opened the door there?
I mean, I think too, if that was that employee's account, potentially, you've opened the door to not having that one protectable. But customer testimonials, essentially, or I would hope so, you've got more than one customer. So if you're just putting up one or two or a handful, I think you're okay. But if you're listing, I've seen some where they list all the customers or a majority of your customers, you're starting to get into that territory where it's probably not going to be considered a legitimate business interest.
Yeah. And let me make a note here because there's a number of PEOs on this call. One challenge a PEO has right now is the fact that the 5,500 filings are requiring a disclosure of the client list. And that's obviously a publicly made available document. That becomes problematic to protect at this point. And it's something that you have to consider. And I could see a good plaintiff's attorney arguing that those aren't protectable interests any longer because you've made it publicly available, although not willingly.
Yeah, absolutely. In addition to valid business justification and legitimate business interest, the agreements have to be reasonable, and they have to be reasonable in terms of duration, scope, and geographic area. So, that generally, well, again, this is going to change from state to state, but 2 years, 18 months seems to be, your typical average. Some states have less, some states have more. Some states like California, you can't do a non-compete at all. The scope of the agreement, so you can't just necessarily prohibit somebody from working for any other company in any other business, doing any other thing in any other role. It has to be limited reasonably in terms of the scope of what they can't do. So you can't necessarily go prohibit your salesperson from going to work for your competitor as, say, a janitor, for instance. Because there's really, again, that gets back into your legitimate business interest and justification for having the agreement. You can stop them from going over and being a salesperson for your competitor, provided everything else is met. But you just can't have a blanket prohibition on any other employment, and they have to be reasonable in geographic area and or sometimes customer. Or specific list of competitors also can qualify in that, and that's really, really fact dependent. In fact, all of this is fact dependent, depending upon the individual circumstances, because some people, for instance, in New York City, a reasonable geographic area could be a 5 to 6 block radius. Whereas in Pittsburgh, it could be more like 50 or 100 miles, or the entire state of Pennsylvania. There are differences, from in the terms of the restricted areas that go, geographically. And the agreements have to be, like all contracts, they have to be supported by valid consideration. So typically that would be initial hiring, at will employment, continued employment, a bonus. Actually replacing and nullifying a invalid non-compete agreement and replacing it with a valid one could work. You have to give the employee something of value, a one-time bonus, a raise, participation in a stock plan. The consideration can't be illusory, and it can't be something that everybody else gets. It has to be something special for the employee. So for instance, if you give somebody a bonus that is completely discretionary, and you never pay that, the promise of a bonus that's completely discretionary and they never actually get that bonus, that's not going to be valid consideration. And you see I've got an asterisk here next to continued employment, and note that's only in some jurisdictions. There's a lot of jurisdictions, Pennsylvania being one of them, that does not recognize continued employment as valid consideration for a non-compete agreement. So you have to give them something else.
Wait, what happened here? Okay. So we talked a bit ago about President Biden's executive order. So some of you were on our webinar with me in September when I first unpacked this for you. Essentially, nothing has changed 3 months later. Basically, the president has empowered the Federal Trade Commission, which oversees business practices, including unfair business practices, to limit somehow the use of non-competes if they unfairly limit worker mobility. What I found interesting is that coinciding with his comments about how this was going to open up more movement, this was in a press briefing back in July. Since then, I've become very aware of this great resignation and movement of workers, folks getting paid more that aren't subject to, and I think it's just a dumb luck coincidence that because of the pandemic and people aren't really wanting to work right now, that employers are having to pay higher wages and incentivize people to come to work. I don't think it's because there's been a radical shift in the use of restrictive covenant agreements. In fact, I continue to see them used, and I have plenty of clients still seeking to enforce them. Now, the question will become what the FTC is going to do with these rules, and ultimately, where we're going to end up. And so, I mean, logically, there are three sort of paths, right? It'll be a federal ban on non-competes, or is it going to be limited in some way? For a non-solicitation component, is it going to be just restrict certain activities? Because a non-solicit doesn't bar somebody from taking a job. And how do you reconcile state and federal law here? Historically, states have sort of captured the field here. There was no federal preemption of non-competes because there's no federal legislation right now. So this could come into conflict with various state laws, which are already subject to nuances, as David explained. So, I mean, logically, this could end up in court. Now, again, there's no immediate action. It's just sort of, hey, if the FTC moves on this, or if there's judicial action, just beware. So wanted you to know that. I do want you to also, though, be mindful that some non-competes ultimately may be patently unfair or archaic and need to be updated anyway. So bear that in mind. With that, I'm going to let David talk about some state non-compete / restrictive covenant laws that are coming to a head in 2022.
Yeah, and Gordon, before I get into that, have you heard anything about the FTC taking any action to move forward on this executive order? I mean, because it seems, it was issued in July, and then shortly thereafter, then Delta showed up. And then we have the flurry of vaccine mandates and the announcements. And it seems almost like this was a small blip on the radar that didn't get a lot of coverage because of everything else that was going on. So is the FTC, again, knowing what we know about the Great Resignation, are they still moving forward with this, or they kind of put it on ice because it may not be necessary right now?
So I've heard absolutely nothing that indicates there's any.
Either have I.
And to that end, I think the vaccination agenda has taken the forefront, and this has gone somewhere in the background as a sort of wishful long-term part of a campaign platform that isn't as relevant when you see unemployment historically low and you see people with many sectors, and you can read any reputable newspaper or business trade publication. A lot of sectors, the average wage just keeps going up. So maybe the collateral effect of threatening with the FTC action has already accomplished what their inaction hasn't necessarily, stepped in. But maybe that's the product of why nothing has transpired.
Yeah, no, it's interesting because it was announced and then silence from everywhere. So, but talking about a couple of states and look, so we've got up on the slides here 3 state statutes that have been amended or updated for 2022. But it's important to note that not all states have statutes that govern the enforceability or the permissive use of non-compete or other restrictive covenant agreements. A lot of this is done by case law. Pennsylvania, again, I keep going back to Pennsylvania because I'm physically located in Pennsylvania, but Pennsylvania does not have any statute that deals with restrictive covenants. So everything's developed by case law. So it would take, again, a couple of days to go over all the developments that happen in every state's restrictive covenant law. So we're going to focus on those states that have statutes and have updated their statutes for 2022. So the first one, Illinois is back again. And in addition to their wage and hour law changes, they have something called the Freedom to Work Act, which governs and sets various standards for the enforceability of non-compete and non-solicit agreements against employees. Some big changes effective for 2022 is the first one is they can only enforce a non-compete if the employee earns annually $75,000. So employers cannot, if you enter an agreement with somebody less than $75,000, that agreement is void, with a caveat that I'll get into a second. And that's going to keep changing as the years go on. But for 2022, it's $75,000 minimum. Non-solicit agreements, if you want to have a non-solicit agreement with an employee, it's got to be $45,000 per year on an annual, $45,000 per year minimum in order to have a valid non-solicit agreement. And another fun change that they made was, we've just gone through or currently still in the COVID-19 pandemic. And they actually wrote into their law that says that you cannot enforce, it's actually void and illegal for any employer to terminate, any employer to enforce a non-compete agreement against an employee who is terminated, furloughed, or laid off as a result of business circumstances or government stay-at-home or shutdown orders related to the COVID-19 pandemic. I hope we are past all of that. Or they wrote under circumstances that are similar to the COVID-19 pandemic. Unless you agree to pay out the employee their regular salary during the time period that they are going to be subject to and not be able to go work for a competitor. So they're mandating sit-out payments in those circumstances. I'm curious to know what a circumstance that is similar to the COVID-19 pandemic might be, because I hope to God this is a once-in-a-lifetime event that we don't have to deal with again. But I guess we'll have to, legislatures like to write vague laws and leave it to people like Gordon and I to interpret and argue over. And that, I'm assuming, is going to be something that's going to be litigated. They also made some other changes that essentially codified Illinois case law that had been developed. For instance, you can, they codified various requirements that have been developed over the years. Adequate consideration has been defined as the employee has to work for you, for the employer, for at least 2 years after signing the agreement for the agreement to be enforceable, or there has to be other quote unquote adequate consideration that is paid in addition to their employment if they work for less than 2 years, such as a bonus or some other benefit that happens if they work for less than 2 years. Again, if you're looking at legitimate business interest, it's going to be dependent upon the totality of the facts and circumstances. Again, codifying case law. And you have to advise the employee in writing to consult with an attorney before signing the non-compete agreement. And you have to give them 14 days to review the agreement before signing it. They also codified the blue pencil rule, which if you know what the blue pencil, if you deal in this area at all, blue pencil rule basically says that you can, a court can modify the, an unenforceable or an invalid provision of an agreement. The court just, or excuse me, the legislator just wrote that into the law. They also allow employees who prevail in the action to recover attorney's fees against their employer who sought to enforce the agreement. So if the agreement's deemed to be not enforceable or the employee wins the lawsuit, they get to recover their attorney's fees. Note, however, the employer is not allowed to do that for the employees, against the employees, excuse me. Oregon, they made 4 major changes to their statute about restrictive covenants. So they said that non-compliant covenants not to compete are void instead of voidable. There was apparently some confusion in Oregon based upon the use of the word voidable. They thought that they had to, if the agreement was invalid and didn't comply with the statute, that the employer needed to do something to void the agreement. Now it just makes them automatically void. They also shortened the restrictive covenant period. So before it was 18 months for a non-compete. Now you can only have a maximum of 12 months from the date of the employee's termination. Agreements longer than 12 months are void and unenforceable. It's interesting, and it's unclear to me whether or not that means if you have an 18-month agreement, if that agreement in and of itself is void and unenforceable, or if it is just going to be blue penciled down from an 18-month to a 12-month agreement. But when they use the words void and unenforceable, that's some strong language that says to me, maybe the entire agreement's over and you got to have a new agreement entered into. They revised the minimum salary threshold for people to be subject to a non-compete agreement. You have to meet one of their white collar exemptions, so your executive, professional, administrative exemptions. And they used to have a vague median family income of a 4-person family as determined by the Census Bureau. They got rid of that and just said you have to make $100,533 annually to sign a non-compete. Why they didn't just make it an even round 100,000, I don't know, but they threw in that extra $533 as well. That's going to be adjusted for inflation annually. And then if you want to have a non-compete agreement with an employee that does not meet one of those white collar exemptions, you can do that in Oregon, but you have to pay that employee at least 50% of the employee's annual gross base salary and commissions for the entire time that the employee is going to be they're sitting out during the non-compete, or the $100,533 adjusted for inflation. So you have to pay them 50% of one of those two amounts. It's unclear to me if it is it is the greater of those two numbers for them to sit out. They don't change the anything else in that law with these amendments. So that's it for Oregon. And then Washington's a pretty straightforward change. They just increased the threshold for the dollar amount that you have to enter into. So for 2022, it goes up. In 2021, it was $101,390. And in 2021, it went up to, you'll love this one, $107,301.04. Again, this was adjusted for inflation, so it was a formulaic adjustment, which is why we've got cents in there. But I would have thought that they would have just said, let's round it to an even number. That is for employees. You can also have non-competes with contractors. And in 2022, that you have to be paying your contractor at least $268,252.59 to have an enforceable non-compete agreement with one of your independent contractors. That's it for the state updates on non-compete law.
Excellent. All right. So now we're down to, now you got to hear all that great stuff about non-compete. So what are our best practices? Well,
you're going to wake up for this part because I think we just put them to sleep. They're going to wake up now.
Well, I think, David, you hit on an important element, which is, so if you have an agreement that on its face may be in conflict with a new state law like the Oregon 18 versus 12-month duration, it would behoove you not only to consult with counsel, but it may be a safe play to update in ways in which you know that you may have something that could be deemed per se unlawful. So that would be my first takeaway. David, I'll throw you to go for the next takeaway.
Yeah, we were talking about before. Does a restrictive covenant still make sense for you and your business? With the Great Resignation, employees have got a lot of bargaining power, and it may be an impediment to, we right now employers need employees, and does having a non-compete agreement as one of the subjects of hiring the employee prohibiting you from gaining new talent? Or do you even still need the non-compete? You used to have it to protect various, maybe, technologies or customer base. Maybe you don't need that anymore. Telecommuting is also out there. So, do we have to expand the geographic restriction for future employment? Because there's tons of people that were working in New York City that have now moved all across the country because they realize that they don't want to live in New York City and pay New York City prices, and they can do their same job from Montana, and not have to deal with those high prices and everything else that happens in New York City. So,
Right.
Are we going to have to update the agreements in that regard?
Well, and then that begs another question. There's another way to protect your legitimate interests, which is, can you get by with just a non-solicitation? So, for example, if you have salespeople that leave and you don't want to call upon your customers for a competitor within a territory, can you just get by with a non-solicitation that just bans them from reaching out to customers they had dealings with at your company?
Or a confidentiality agreement that's got a little bit more teeth to it. Could be another way to do it as well. Yeah.
Yeah, because those aren't a restraining frame. Nobody's saying you can't get a job. You just can't
Right.
go after our customers. That's a way less restrictive means, and in a lot of states, there's a lower scrutiny applied because of that. So that could be more beneficial.
Yeah. And in some states, for confidentiality agreements, you don't even need consideration in some states. So that's, you don't have to shell out more money for a bonus. And most courts, unless they are, in my experience, unless they are overly restrictive, I can't say that I found a court that struck down a confidentiality agreement. Because, unless, again, going back to, we got to protect the identity of our customers, and they list that information on their website.
Right.
But, I frankly haven't dealt with a court that struck that down. So.
Yeah, well, and the other consideration is, like you said, with the changing landscape of modified work arrangements, remote, or the globalization of businesses. Again, I can talk to the PEO space. A lot of PEOs have become a national PEO because, boy, workers started working at home across a bordering state. Now all of a sudden, you're paying somebody in a different state. So, does that expansion make it problematic? Because a restriction of saying you're selling all over the United States and you cannot go sell with competitor X anywhere in the US. Think about it. Are you going to argue to a court, we're happy for this person to take a job in the industry, but they have to go to Mexico or Canada in order to do so? So
Right.
the takeaway there is, make it as least restrictive as you reasonably can to make it still have some teeth. And in a lot of states, including Georgia, where I am and where our mothership is located, I firmly believe that material contact is probably a safer play, because, as I used the example of, if you met client X at a company holiday party, shook their hand, but know nothing about who they are and why they're there, arguably you had contact with them, and arguably that would then restrict you from knowledge of any client that you may have dealt with at all. Meaning more vague and more broad would bar you in that illustration, which of course is kind of ludicrous, because you don't have anything that's confidential, proprietary, useful to be able to move that person's business. But there are plenty of agreements that are worded in such a way that would apply.
Mm-hmm.
I think another consideration is narrow the scope of the competition, meaning, if I'm a salesperson, then restrict me from being a salesperson. My classic example I always give people is if I am the janitor, do you need a non-compete for me to, because if I'm going to go work for a competitor and do the same work, what do I know and what can I do that can actually hurt your bottom line in that example? You know, so if I take a different job or I'm not in a position to, you know, take customers, you have to be practical. There are just other ways to get there.
Yeah, I mean, I think, you know, everything that you and I just spent the last 2 or 3 minutes talking about, I think it all comes down to what we've got on the very last line of this slide. Review what exactly it is that you're trying to protect. So start from that premise, you know, why do we need this? Why do we want this? You know, what is it that we need to worry about if this employee or group of employees or type of employees leaves? And then formulate your strategy and formulate your agreement or agreements from there. You know, start from there and then, you know, work forward from that point.
Right.
Because without that, you're not, it's good. You're going to run into issues.
Absolutely. Well, and we don't have time for, nor have we addressed the cost of enforcement. Litigation is very expensive. And as you illustrate in some cases, loser doesn't always pay. So if you beat the employee, you don't necessarily get to recover everything you invested in pursuing the covenant. And I tell this to a lot of clients, and some of you on the call have heard me say this, you are also dealing with a subjective interpretation of a law, meaning the judge that you have hearing the case very much may have their own view of what is or isn't an enforceable agreement and what isn't overly broad or otherwise burdensome in enforcing the covenant. So it's a luck of the draw. I mean, if you had, you know, you got Judge A who's more liberal and will look at these things from a tougher view versus Judge B who's more conservative. Completely different outcome. So it doesn't mean you're wrong or that you didn't have a good agreement. I mean, what I tell people, David, is these agreements are a deterrent to get employees to think twice before they leave, but I can't promise they're ironclad because there's a subjectivity, as I explained, because the law is in flux, because our president wants to scale these back. There may be a public policy consideration that pushes you into a position of, it may look almost unfashionable at some point to use these. We don't know. So a lot to think about, but I'm not saying don't use them. I'm saying there are some pitfalls and you need to know full disclosure what you're doing. And I wouldn't use the same agreement across the board for every employee that walks in the door. Because as I explained, that janitor doesn't really need to be bound, or that low wage earner at the drive-through at a fast food franchise is a classic example. You know, that's not who we're tending to target. In some states, actually, that becomes illegal.
Yeah, and again, not to make a shameless plug for what it is that we do, but you know, I think in just about any other area of employment law, this is one of those areas where you got to get your employment counsel involved because of all the nuances that are involved with this. And you know, like what you just said, you may know that, okay, well, you know, if you're trying to enforce it in these 4 counties in Georgia, you know, you don't have a chance versus if you're trying to enforce it in these other 4 counties, you know, it's, you know, it could be closer to a slam dunk. I mean, it's one of those things that's, you know, this is where money spent on the front end will get you, save you a lot of money on the back end.
Yeah, you remind me of something funny, which I'll tell you real quick. So used to be, you could pick your judicial assignment in some federal courts, and there were literally circumstances where if a judge was assigned to a case, a plaintiff's lawyer would dismiss the lawsuit and refile to avoid that judge. So you can't really do the forum shopping like that now in these cases. And plus they're going to be heard by probably a state judge, probably limited choices. Although you could bring again, I don't want to get into the weeds, but you could bring a non-compete action in a federal court if you have diversity of citizenship or other requirements that allow a federal court to hear it. So not impossible, but they may not be as versed on the law. You may think you're getting a better deal, but you may not. So, yeah. All right. Well, let's get ready to wrap this thing up. So the guy on your right, that's David. The guy on your left, it's me. Here's our information. If you want to follow us on LinkedIn, have at it. Love to have you. If you want to connect with us, yes, by all means. If you would like to be on my legal alert, which I send out every Friday and you're not getting it now, send me an email. You and colleagues happy to add. If you got on late, which a few of you did, still glad you made it. But if you missed the beginning, this is being recorded, and I will post this as soon as possible on my YouTube channel. You can also review all of the prior webinars that I have presented on, including one with David that I did a few months ago with some of the other Hall of Legends that I work with in our employment department. So seeing that there are no questions and we're almost at the top of the hour, I'm going to stop the recording here in just a moment, unless anyone has anything they want to last minute hit. And if not, I really appreciate everybody being here. David, as a guest, you did an admirable job of making me look good. Thank you. And
Thanks for having me.
everyone, enjoy the holiday season. I will circle back with you again after the first of the year with another exciting webinar where we will once again confuse you and attempt to tell you that the law is not easy and why you need lawyers. But that being said, thanks again, everybody, for your time and attention.